Good morning. Thank you all for joining. My name is Bianca Simmons, the Pro Bono Programs Coordinator with the North Carolina Bar Foundation and Coordinator with NC Lead. Today we have with us attorney Elizabeth Brooks Savage, presenting to you the Small Business Guide for Brand Protection and Trademark. Elizabeth is a North Carolina attorney practicing intellectual property, administrative, and business law with Matheson and Associates, PLLC. Her legal practice is focused within the fermented and distilled beverage industry with various business needs, including trademark protection and enforcement, permitting and license, entity formation and operations, and contracting. She does it all. She also uses her experience in education in public health and disaster recovery to help our clients navigate issues involving risk management, health codes, infectious disease, and government relief programs. Elizabeth is active in her local state and national bar associations and volunteers her time to provide pro bono legal assistance and community service through various organizations and programs, including the North Carolina Lawyers for Entrepreneurs Assistance Program, NC-LEAP, 4-Day Olive Service, Miracle Leaf of the Triangle, and Disaster Legal Services Program. I will now pass it on to Elizabeth. Enjoy the presentation and please feel free to ask questions throughout the webinar and we will answer at the end.
Welcome everyone and good morning. Thank you for joining this presentation. Today we're going to really focus on protecting the brand that you are so diligently developing for your business. Branding, especially this day and age, is probably one of the most important assets that you're going to have as a business owner. So it's important to get it right, especially at the outset. Not that you can't amend things along the way. You know, part of business is growth and development. So of course things are going to change over time. But as much as you're able to get this in the right step moving forward at the initial outset of your business plan, it's going to really put you in a better position in the long haul. All right, we will jump right into it. So I packaged today's presentation in a 5-step guide. This is a lot of information to cover, so I'll try to do as much as I can in the time allotted this morning. But of course, if you have questions, please do follow up with the program, or again, at the end of this presentation, we'll be taking a Q&A session. So today we're going to cover the 5 steps. Step 1, identifying your intellectual property. So we'll cover a little bit about what is IP and the different types of IP that you probably already own. Step 2 is assessing the status of your IP and making sure that you know, you've really thought through steps of what your competitor's doing and how you're protecting all the different types of IP. But then we're really going to focus in on the brand protection. So that's going to be trademark. So step 3, we're going to be talking about trademark registration. Step 4, monitoring for infringement, that folks could be using your trademark and what you can be doing there. And step 5, using enforcement strategies. And specifically in land of trademarks, enforcement is the name of the game, which is why things like registration and protection at the outset are so important. I will go ahead and say before I move forward that this presentation is being provided through NC-LEAP for informational purposes only. I am not giving legal advice. I'm not representing anybody individually or any of your businesses today. If you are in this presentation, you watch this afterwards in the recording, you're thinking to yourself, oh wow, there are things I'm learning that I probably should get an attorney for, or I may have further questions on, strongly recommend you seek a business lawyer or an intellectual property lawyer for those specific questions. All right, so moving on to step 1, identifying your intellectual property. Intellectual property essentially can be thought of as property, right? A right and property that you own that's just not necessarily something that you can tangibly hold. Some of it you can tangibly hold, but you know, there are different types of property in the law, right? You've got real property like land, your house, you've got physical, personal property like your cars, jewelry, and there's intellectual property, things that we come up with, the property from our minds. So I did also add in here, the USPTO has recently launched an IP identifier tool. I've put the link in there for you to go check that out if you want to. I played around with it earlier today. It is fantastic. And on that note, the USPTO, the United States Patent and Trademark Office, has a fantastic bank of resources. If you haven't looked at that agency yet and the resources that they offer, recommend that you head that way right after this presentation, because they really have a lot of guides and resources to help walk you through this process, because it can be tricky, and not everyone can afford an attorney at the beginning. And some of this, I do believe, if you put the time and the effort into it, you can probably get yourself at least 50 to 75% of the way there. So yeah, that IP identifier is great. It really helps you understand what you might be holding, but we'll go ahead and talk about that today. So there are different types of intellectual property. Trademark, which this presentation is going to focus on because trademarks are at the core of business branding. Trademark protects your brand. It protects how consumers are identifying your goods or services and relating those to what you're providing as a business. Trade dress, it's actually a type of trademark, but it's kind of like the way you dress up your package of products, and how you're configuring your goods or services. Patents, there are lots of different types of patents. I will say there's a difference in the legal profession between patent attorneys and other type of intellectual property attorneys. Patent attorneys must go through a separate application and certification process. And so if you are dealing with any type of patents, definitely want to look into getting a patent specific attorney. Copyrights, that's going to protect works of art and authorships. There's a separate agency for protecting or registering copyrights, as there is to registering things like trademarks and patents. And trade secrets, that's going to protect your confidential information. And a little piece about trade secrets, some folks think that there's a way to register secrets in some sort of system or registration system, and that's not the case. There is no registration system for trade secrets. It's really just a set of policies, procedures, and ways that you do business to be able to protect the confidential information that you have. That's really important to either your business or the product or service that you're selling. And I'm not sure if I mentioned this earlier, but patents, those things protect our ideas and inventions. All right, so step 2, assessing the status of your IP. Already know that there's a ton of different types of intellectual property out there. So the first step is just, what IP do you have? You probably have a handful. And all of these questions that we're about to talk about can relate to each individual set of intellectual property that you have. So what IP do you have? Do you have a trademark? Do you have a logo or a name that you're doing business under? Have you created an invention that you're selling or that you use to sell something? Have you written a book? Have you developed a piece of art? Are you in the music business? Have you recorded something? Have you created something? So thinking about what it is that you're doing, what products you're selling, is going to help you figure out what kind of IP you have. But then let's get to, how is it protected? Different types of IP are protected in different ways. Today we'll focus on trademark, but trademarks are protected in a different way than copyright. It's a different set of law. Similarly, patents are differently protected from trademarks. And as I mentioned earlier, trade secrets, there's no registration system. So you've got to be diligent about what you're doing internally, how you're working with employees and third-party vendors to make sure that your information stays private. Do you have a monitoring plan? And monitoring plan is, when I reference this, I mean, are you monitoring your use? And are you monitoring the use of others in your market and industry? So how are you using your mark? And checking in periodically to make sure other people aren't using it, which gets to the next point. Are other people using your IP? That's going to be a problem. Brands, a lot of value that you own as a business is in your brand, and you don't want people infringing on that. And so if they are, you need to be able to figure that out pretty quickly. And onto the next point, enforce your rights, right? If somebody is illegally using your property, you need to make them stop. And we'll get on later in the presentation on different strategies that you can be thinking about to enforce your IP rights. But of course, all of this is just going to look different depending on what specific type of intellectual property you're working with. Another consideration is, what is your market and industry competition doing? In the world of trademarks, this is extremely important because the whole point of a trademark, the whole point of developing a brand is to set you apart from competition, to make you different, and to let consumers immediately be able to identify you and relate your goods and services to your business. So if you're doing something that's similar to somebody else that's going to be a problem, and if you've already established yourself in the market and somebody else is doing something similar to you, that's going to be possibly a dilution or infringement claim. And lastly, what's your business plan saying about all of this? And does your business plan consider your IP at all? And does it consider possible legal costs in your budget to be able to handle these issues as they arise? All right, step 3, consider trademark registration. So as a brief overview, what is a trademark? Well, a trademark, I've mentioned it, I think, a couple of times, as I will do it again. Trademark indicates the source of goods or services. It identifies your goods or services and relates them to your brand, your business. It's how consumers know what you're doing. Um, okay, so let's think about common types of trademarks. The easy ones are like Nike and Coca-Cola. Those are so pervasive. I think we all, at least, in the United States, we've come across them at some point, and they come in different forms. So different types of trademarks. Let's think about it. Text mark. This includes slogans. So Nike owns the word Nike. They also have the Just Do It slogan, right? Those are trademarks, and those are protectable. Design marks. Nike has the little, swoosh check mark. That image, that design is something that Nike has created and owns as a business and uses very consistently to relate people to its goods and products that it sells. So your business probably does have something similar, like a logo or a graphic design. One of the very first things, especially in today's age with social media just everywhere, and the fact that we all at this point are using websites and working with graphic designers and website designers to make our branding look intriguing and draw consumers into our products, right? Well, you're probably using a design mark in some form. It probably has text in it. So you're using some combination of text and design marks already. Special form marks are also something that are considered trademarks. They can include sounds and colors. Think about, okay, the NBC, there are little like dinging noises, right? That occur at the beginning of every special. That's something that would be considered a sound mark. If your business consistently uses a very specific color, I'm thinking as an example, Pepto Bismol is that very interesting color of pink. You see something in that bottle and it looks like that pink liquid. You don't even need to read the logo. You don't even need to read the text. You're probably thinking it's Pepto Bismol, right? So that's similar to special form marks, and that gets me also into trade dress. This is about packaging. This is considered a type of trademark, and all of this type of stuff is registrable if you choose to register. We'll get to registration next. But packaging is all about how are you presenting, right, your product or your services. Mostly products. I think there could be some very unique situations where you're packaging a service or presenting it in an interesting way you might want to protect. But most of the time you see this with goods, with products that you're selling. You have a very interesting package. Going back to Coca-Cola, they have a beautiful glass bottle shape. It's that sort of hourglassy look. nobody else is using it, and you wonder why. They probably have a trade dress protection over that because that's their bottle, that's their image, that's how they're using packaging to convey their product. And service marks. So I mentioned a couple times goods and or services when talking about trademarks. Um, you can trademark something relating to a service. It doesn't have to be just a product you're selling. It could be services that you're selling. So in those situations, you might have service marks. All right, so where do trademark rights come from? Another common misconception is that you have to register. They come from the registration system. If you don't register, you have no rights. That is not correct. That is a misconception. Trademark rights arise out of use. And sometimes we call this common law rights, right? And in the legal words that we like to use, in the profession. But really what I'm saying is they come out of just using them. So if you've developed something, you've put it out there, you're using it, you've developed a trademark. You have rights in it. The question really is, how strong are your rights? And are your rights stronger than anybody else's that may have a claim to the same or similar mark that you're using? So most of the issues you see in this space are not necessarily around whether what you've come up with is yours, but whether what you've come up with is so close to somebody else's that you can't claim it as your own. All right, we'll move on. All right, so we're still in step 3, but this, getting into the registration process a little bit. Registration is not mandatory. So because, of what we've talked about with common law rights that can arise out of use alone, you don't have to register something to necessarily own it. But it's probably a good idea, which is why everybody does it. There are various benefits that come from the registration process, but they're also limited to the type of registration system that you use. So there are state registration systems. Similar, if you're a business owner on this webinar, you probably have had to file a thing or two with the North Carolina Secretary of State's office, right? You have annual filings every April. By the way, that passed. So if you're watching this now and you didn't do that, please go look into that to maintain your business filings. But yeah, North Carolina and other state entities have registration systems for trademarks. This used to be a lot more popular years ago. However, again, with the rise of interstate commerce, so commerce between multiple states, um, particularly with using e-commerce and websites to be able to sell your goods or services, well, goods really, yeah, you're probably going to just jump straight to the federal registration system, because at that point you don't need protection just in one state. You need it in all the other states that you're doing business in, right? So state registration really isn't as popular as it used to be. That being said, it's still an option, and frankly can be a fantastic option if you have a trademark or have an idea for a trademark, but somebody else that's using it in the USPTO registration system, there's a conflict with your idea and theirs, or your mark and theirs, and it might not rise to the level that it could lead to any real litigation or any other type of infringement disputes, but it's enough of a conflict to prevent your actual registration with the USPTO. If that happens and you're still so committed to this mark and you won't really see yourself using it outside of the state of North Carolina anyway, well, then maybe state registration is a really good idea for you. But again, if you want to set yourself up for a little bit more growth and expansion, you're either intending to do business in other states or you already are, then federal registration is probably the way to go if you're going to register. So with that being said, the federal registration system in the United States is the United States Patent and Trademark Office, the USPTO. And the process of registration can take a very long time. I believe at this rate, I know COVID had, um, a whole just host of issues in the world of business, right? But as far as trademarks go, we're seeing a lot of delays in the process than we did before COVID. So you're probably looking at anywhere between 9 to 12 months to start to finish, maybe even longer than that, depending on how many issues, if any issues pop up during your application cycle. It can take a long time. Um, but the first thing you need to consider when you're thinking about registering is doing an in-depth clearance search. A clearance search is more than a Google search. It's more than a handle search on Instagram. It's going to look at, yes, some common law pieces of what are other people doing that haven't necessarily registered already, but it's really going to get into the weeds of what's already in the registration system at the USPTO level. And the reason why it's important to do an in-depth clearance search is because you don't want to spend all this time and money on actually applying and going through the process just to come to a hurdle that you're not going to be able to overcome in the middle of this cycle when you receive an office action from the examining attorney at USPTO saying that your mark is too similar to something else. So there are a lot of rules when it comes to the examination process of um, whether or not your proposed mark is registrable with the USPTO. USPTO hires and employs a number of attorneys called examining attorneys that go through every single application and do their own in-depth clearance search. They will not do common law searches, right? They're just going to be looking at what's in the system alone. But trust me, there's enough in there. Um, I could not imagine, trying to do this process and also including common law searches. But that being said, um, the rules on the examination of your application, they're pretty in depth. I mean, there's a very extensive manual that covers the different types of things that are and are not registrable, and when there are conflicts with other owners that have registered in the system, how to handle those conflicts. And most of the time, that's not going to look good for you if you're the one who's the offending, or the offending mark, or the conflicting mark with someone that's already registered. So, one of the most common types of conflicts that we tend to see is confusingly similar. That is what it sounds. Your mark is confusingly similar to somebody else's mark. What isn't like it sounds is how confusingly similar is interpreted. So, in my line of work, in the industry I work in, I tend to work with a lot of retailers of alcoholic beverages, right? And doing trademark along those lines. It's not necessarily um, obvious to us that an examining attorney would think that uh, a trademark that isn't exactly the same as something else, but kind of has the same name, maybe the same look, maybe some similar phonetic pronunciations, um, but they're in different classes. So the USPTO does classes of goods or services to try to categorize everything. Uh, Beer is in a different class of goods or services than distilled liquor. Um, and wine for that matter is different. Um, but they're considered similar enough classes that if you put them together with a similar mark, you're gonna get kicked out. I'm also seeing a rise of coffee being interpreted as a similar good to beer, right? That's not intuitive to us. Um, but when you get into the weeds of it, and you read some of the arguments from the other side, I can see where folks are coming from. I might not necessarily agree with it, right? But this is what I'm saying. There are things that are going to pop up, ways that this is going to be interpreted that depending, and it all really depends on your industry for that matter, right? What you're selling, how you're selling it. It might be confusingly similar to something else, and it might not be intuitive to you why that is. So again, clearance searches help try to uncover all that nonsense before it comes up later on. But then we get to the actual registration application. The application itself, everything's online these days. So there's an electronic platform that you can use to do all of this, which is great. Um, but there are various options that you have to form your bases. Um, that being the use basis, right? So going back to how trademarks exist in the first place, it's you're using them, right? So on the USPTO level, at some point before you're ever going to be able to get to the registration part and get your certificate, you have to show that you're actually using your trademark, right, to sell your goods or services. Okay. Well, because the USPTO is really awesome, you don't have to show that at the time of your application. So there's one type of basis for an application that says, yep, I'm using this mark, I've been using it, let's go, right? There is a second option that the USPTO offers, and they call it intent to use, but just how it sounds, right? I intend to use this mark. I'm not using it now, but I'm planning on it. Um, that has to be what they call bona fide. It has to be a bona fide intent. All that means is you got to really mean it, right? Like you can't just go in and put in a bunch of intent to use applications to try to, I don't know, save a lot of options for yourself and then eventually let them all abandon. So you just pick the one you want. That's not what this is for, right? Once you actually land on something and you intend to use it, you're developing. Maybe you know your text, but you don't have a logo yet. So you're developing the logo with a graphic designer. You're in the process of putting together your website. Maybe depending on what you're selling, you're still going through a clinical trial process, or you're still going through other types of marketing development or government approval. All that to say, if you're getting to the point where you know you're going to use this thing, you're just not ready to actually sell it yet, you can still apply at the USPTO. And while the USPTO is really awesome for allowing that, there is a catch. The catch is it just can be a little bit more expensive in the long run because down the road, if you are approved, if the mark is approved but not registered, right? Because to register, you have to show use. Uh, it's just a series of recertifications over a number of months that you're still trying to do what you need to do to get to sell and you just aren't able to do it yet. Those recertifications are or renewals, I guess, however you want to phrase it. They are limited. You can only do, I believe, 5. But at the end of the day, that could, depending on how long it takes to even examine your application, you could be looking at anywhere between 6 months to a year and a half of extra time to just get your ducks in a row before you're actually using your mark in commerce. So it can be helpful for some folks. Okay, so next bullet here is office actions and TTAB appeals. This is the part the clearance searches are supposed to help prevent, but things happen. It's not even necessarily mistakes are made. It's just there's a lot of information and not everything is uncovered. And even if it was uncovered, there are individual attorneys who are these examining attorneys at the USPTO. And while we all have a set of guidelines, we have the law, right? Like that we're following. The interpretation of how someone might look at your mark compared to others really kind of varies on an individual basis. So it really depends on who your examining attorney is to a certain extent. And yes, the process tries to reduce that variability a lot, but it happens. So you could do all things right and still just sort of end up with a conflict throughout the process. The conflict. So what that comes through is in the form of an office action. The initial one would be called a non-final office action. And most of the time, I mean, it could vary. It could be anything from the specimen that you submitted. A specimen is basically proof of how you're using your mark. So the specimen you submitted just really isn't up to snuff. You need to do something different with it. Or maybe you need to disclaim something. You can't register generic words. So it's possible you just need to disclaim a generic word that's within your trademark. I commonly see this with breweries, right? Let's say it's, XYZ brewery. You're probably going to have to disclaim the word brewery because that's kind of describing what it is you're doing. Um, that stuff, don't sweat it. That stuff's really not too tough. I think where things get a little bit dicier, where you might want to consider hiring an attorney to help you, is if it's a little bit more substantive, where there is a problem with the substantive examination of your mark. And this gets to, again, one of the common issues of confusingly similar. Um, you have an opportunity to submit your response there for a non-final office action. You'll have a second opportunity. It'll come back if it's denied again in the form of a final office action. You have a second opportunity, to argue again. You also have the opportunity to appeal up within the agency. So, Trademark Trial and Appeal Board, that's what TTAB stands for. And that's kind of like that second level appeal where it's like you've done all you can with the examining attorney. Clearly, nobody's going to be agreeing on anything, and you need to get a third party in there. You need a judge. So at that point, you're going to have to appeal it up to a judge within the agency to try to get their determination on the issue, and hopefully, resolution is in your favor. But again, never really know what's going to happen sometimes. Well, and if a TTA appeal isn't successful, and at that point you might be looking to have to go pull it outside of the agency and actually sue a court of law. But all of this is very case dependent. This is just giving you, examples of what this process could look like and how far this can go. At that point, though, I don't see a lot of that at that point. A lot of folks just sort of cut the losses and go back to square one, just come up with something different. Assuming all of this process works out, your mark gets approved for publication. It's published in a gazette, the official gazette, and it's kind of like a newspaper that shares with the world all of the marks that have been approved but not yet registered. And what that does is it just provides an opportunity for the rest of the world to see what's going on. And if anybody has any issues or wants to oppose the registration of your mark, even if the examining attorney thinks it's okay, they have an opportunity to do that. It's a 30-day window for someone to file an opposition against your mark. And it happens, it does pop up. And if you have to go back and forth with an opposition proceeding, again, that might be another area where you might want to hire an attorney to help you out there. But assuming there are no issues, no oppositions, everything's fine, it's going to move on to registration. If you've done a 1A application, which is the use space that I am using it now, in the event that you've done a 1B, which is an intent to use based application, then you've got to take another step there. You might be approved, but you can't fully register until you prove that you're using it in commerce. So at the point that you've done that, that gets approved, and then you get to register. And finally, you get the registration certificate that you get to wave around and say, this is mine, and it's registered with USPTO, and you can't have it, right? I do not believe that the USPTO physically mails registration certificates anymore. This used to be a practice, but again, the whole system's really gone paperless. You can, of course, request one or print one out for yourself, but everything's going to be online. Now, something that doesn't get talked about enough, which you should know about, are maintenance filings. Maintenance filings come around every 5 to 6 years, at least at the first set. But the whole point of them is just to know that they exist at this point. A lot of folks think once you've received a registration certificate, you're done and you're registered forever and you don't need to do anything else. And that's not the case either. You do have to periodically go back to the USPTO and recertify, saying that you're still using the trademark, you're still selling your goods or services using that mark, um, show some evidence of how you're doing it, and just basically re-up your registration. If you don't do it though, and you miss those deadlines, then your trademark could be abandoned. And so for folks who've been in business for maybe 10 years, registered 10 years ago, never did any maintenance filings, it's very possible that your trademark has been abandoned and you actually don't have the benefits afforded from the registration system process that you think you do. So be aware of that. And I touched on this a little bit just going through that registration process, but not all trademarks are registerable. There's a huge, manual, but it really, comes from the agency and also statutory law for things that you cannot register. So, for example, you cannot register a geographic place. This in North Carolina, some examples of geographic place or geographic designations that would not be a trademark that you could register be like cities or towns, Raleigh, anything with Raleigh, Charlotte, uh, Asheville, but it could be other cities too. Um, it's likely not registerable. It's likely going to have to be disclaimed if it's included in your trademark. Um, but it can be extended to um, well-known names relating to geographic places like Oak City. Okay, Raleigh is Oak City, City of Oaks, what have you. I think what is Charlotte Queen City, right? Similarly, so in those situations, if you're Oak City Steaks, Oak City might be interpreted to be a geographic place, particularly if you're actually located in Raleigh. And steaks is, well, it's a generic term. You can't own the word steak. So uh, that might be an example of a mark that's not going to be registerable. And also, getting to that second point, generic or descriptive marks are not registerable. So you can't just own words to own them. It's all very dependent on the actual good or service in the industry you're in. A really good example of this is Apple. Um, you know, uh, Macintosh, right? Uh, they own that company. Owns the trademark Apple as it relates to the IT services, electronic equipment, all that. I'm not a big IT person, some industry, but you know what I'm trying to say. They own all of that as it relates to that stuff. But they don't just own the word Apple. They can't prevent someone from using the word Apple describing fruit or really just anything else. But basically, they could prevent someone from using Apple as it relates to what they're doing, but they just can't own it outright for everything else. All right. So moving on to step 4, monitoring for infringement. The burden is on the trademark owner to monitor. So again, can't just stop at the registration certificate. You have it, but what good is it? What good is all that work that you did if you're not monitoring for if other people are infringing on the property that you worked so hard to protect? So and it's on you. No one else is going to do it for you. The USPTO doesn't monitor for you. So you got to get out there and you got to put together a monitoring plan. That might just be periodically doing a clearance search to make sure nothing else is popping up. Maybe doing if you're hopefully, really involved in your market, you already know what's sort of going on with your competitors, but just checking in to making sure they're not doing anything wrong. And if you find infringement, you do need to act fast on remedying that, because again, the burden's on you to stop other people from using your stuff. So moving on to the use of enforcement strategies. So step 5 here. The USPTO does offer the opposition complaint system, um, and that I talked a little bit about that in the application cycle, where there's a point where anybody can come in, that window, the opposition window or publication window, and say, I don't like what you're doing. I think it's too similar to what I'm doing. I'm going to oppose it. That's on you to have to go through that process and to submit that complaint and to put forth basically all of your points of why you think it's a problem. But it's an option. But again, another reason why monitoring is so important, you have to catch it fast. You only get 30 days. You might be able to get some extensions to help you out there, but that's going to turn around really fast for you. Other enforcement strategies, cease and desist letters, that's going to be like your first line of defense, really, at the point that someone's out there using it already. And you may or may not want to, have an attorney help you with drafting and sending those. But those are just sort of like the little nasty grams that say, hey, cut it out. And they can, maybe your first one can be a little bit nicer, but I think in this industry, at least in trademark law, people tend to go hard pretty quickly. So I don't think anyone would judge you pretty fiercely if you weren't nice about it. I think people pretty much expect to receive nastygram on these things. Another enforcement strategy. So this is becoming more and more common. Cyber squatting, right, and domain name disputes. Um, the UDRP is the Uniform Domain Name Resolution Process. There's a complaint process here that you can use to try to get a cyber squatter off of your domain name. You're trying to purchase it and they're being unreasonable, or maybe they've taken it intentionally to try to divert business away from you. All of this stuff can be remedied, but it's this whole separate process for this stuff. It's not through the USPTO. It's through a different organization. So just be aware that that is something that you can use to your advantage for enforcement. And yes, so there's infringement and dilution disputes. Maybe you sent a cease and desist letter because of a dispute related to infringement and dilution, and you're not receiving any feedback or any response. All right, well, then we need to think about litigation strategies. And at that point, you might want to talk to an attorney to make sure that you're thinking through what you need to think through, and particularly because there are, in certain court settings, businesses cannot represent themselves, right? So if you're a business that the business owns the trademark, the business has to bring the action, right? So also might need to get an attorney to help you navigate that. And sometimes this doesn't actually lead to trial. Things can settle and you can end up with license agreements and ownership transfers, where basically you're even without a dispute situation, you can transfer ownership of intellectual property. It's just like selling a house. You're just selling your trademark, right? Or license agreements are kind of like rental agreements in the sense of real property. Not a great example, but I think a good enough one to get the point across. You can license the use of your trademark. Someone else can use it for certain in certain ways or for certain reasons, and you can profit a little bit off of that. So that could be another enforcement strategy too. All of this to say, the benefits of registration become very clear when you start thinking about enforcement. So this is the why. You don't have to register. Going back to that very beginning, it's not a requirement. You don't have to do it, but people do it because of all of these things. All of these things that can pop up where you need to be able to show affirmatively you own a mark, you've owned it since X date, you have the right to use it. And registration, one of the best things there is that the certificate itself, having gone through such an extensive process, the whole point of it helps you to have a presumption of ownership. So you can walk into court, show that certificate, and say, yeah, I'm the presumed owner here. If you're working with common law trademarks, you have to go through a lot more steps to prove that you have the better rights in something. You have to go through all the steps of where you've been using it, how long you've been using it. Um, you bypass all of that, having already done the registration process. And it also gives you, access to federal courts, which if you're gonna have to do this stuff, you're probably gonna want, right? All right. So I think we just sort of flew through a bunch of stuff, but I wanted to leave time for questions. And I think we've got a good bit of time here. So if we have any questions, I'm happy to take them.
Not seeing any questions just yet. Do we have any questions? Still. All right, so it looks like we don't have any questions. Very detailed and great presentation. Thank you so much, Elizabeth, for all the great information that you shared today. And thank you to everyone for attending and participating. Oh, thank you, Jill. Thank you so much. I'm so glad. Jill said, thank you. This was incredible, helpful information to share with small business owners. Also, this webinar will be available within a week on our website at the ncbarfoundation.org. I'd like to thank our program partners, Mount BizWorks in Asheville, Prosper and Climb in Charlotte, and the small business hubs at Fayetteville State and East Carolina University. If you have any additional questions, please reach out to us by email at foundation@ncbar.org. And thank you all again and have an amazing day.